One last speaker, Sarah Geraghty.
Good afternoon. My name is Sarah Geraghty. I'm a lawyer at the Southern Center for Human Rights in Atlanta. The Southern Center is a nonprofit office that represents indigent people in a range of civil and criminal cases aimed at improving fairness in our criminal justice system. And we represent people in city and county municipal courts charged with misdemeanor traffic offenses with some frequency. And I come before the committee today to testify to the urgent need for some of the misdemeanor probation reforms that are contained in this bill. We are not in a great place in our misdemeanor probation system right now. 80% of people on probation, on misdemeanor probation in the state, are supervised by private companies. And in too many jurisdictions, the private probation companies and indeed some of the government run probation supervision entities have been allowed to run the show with too little oversight. Georgia has the highest rate of people on probation in the country by far, about 4 times more people on probation than the next highest state, and that's because we have allowed private companies to take over our misdemeanor probation sentence. In 2014, the Department of Audits released a highly critical report about misdemeanor probation, finding that a lot of people are placed on probation, just like Chairman Powell said, just because they don't have money to pay on the day of court. Some companies use coercive tactics. At my office, we see case after case in which probation entities use incarceration or the threat of incarceration to coerce payments from poor people. Just last week, I represented a man down in South Georgia who was put in jail because he didn't have $500 to pay his fine for burning leaves in his backyard without a permit. I have example like that I could go on with. I know it's the end of a long day, so I won't. But I will say that there is good news in that this bill contains many important, comprehensive, and much needed reforms that will change things for tens of thousands of people who come before the courts. And I just very briefly will highlight a few of those. One, it requires judges to take certain steps in cases where a defendant is indigent. Specifically, the bill says that a judge shall, and that language is important, shall waive, modify, or convert a fine and fees if the court finds that the person has a significant financial hardship. This is huge. It's a huge step in the right direction. It codifies the constitutional rule that judges have to conduct a hearing to determine if a failure to pay was willful. Again, a really positive step. It caps the length of time that a probationer can remain in jail for failure to pay or failure to report. And it increases transparency significantly. Right now, the law says that all records of private probation companies having to do with the supervision of people on probation are confidential. None are available to the public, and this legislation makes very important, significant reforms to transparency of the system. I'll just leave with this thought. You can talk a lot about big government, or you can do something about it. And from our perspective, this bill is a principal compromise. The parts about reform of the misdemeanor probation system, a principal compromise between a lot of stakeholders, district attorneys, judges, advocacy organizations. It's the result of hundreds of hours of work by Judge Boggs, Tom Swarthy, members of the council, people from the governor's office, and others. I'll just end with this, if I may. Our organizational mission is in part to reduce over-reliance on prison, inappropriate use of policing, and that sort of thing that we've heard about today. Coming from that background, I just don't think that this bill spells Armageddon or the creation of a police state. Many of the criticisms that we've heard have been general but legitimate criticisms of the existing criminal justice system. And they identify problems that exist now and will probably continue to exist regardless of whether this bill passes. There are some parts that we would like to see changed, most notably in line 616 to 23, the use of chief supervision officers rather than superior court judges to conduct probation revocation hearings. That's one thing that if the committee is so inclined to make an amendment, that we would feel is an appropriate amendment. In conclusion, we feel like there could be a few line tweaks here and there, but that this is important legislation for the committee to consider.
Thank you very much. Senator Albers, do you have a question? Senator Albers.
Thank you as well. I know everybody who spoke here today is very passionate and knowledgeable. One of the things that you said that I'm concerned about is the amount of people on probation. Just like we had a way too high level of incarceration per capita, we still do, right? But at least it's directionally correct. Is it your testimony today that you believe that because of this bill, which is imperfect, by the way, there's no perfect legislation. If I was going to vote on perfect legislation, I would never vote for a bill. But based on that, would you say that you believe that the probation, the amount of people on probation will go down based on this legislation?
I hope that that's true. I think that you're right, this is imperfect legislation. I had hoped for a bar on pay-only probation completely, but I do think that the part of legislation that caps supervision fees for pay-only probation is an important step in the right direction. I think that the answer to your question is yes, because there will be cases now in which the judge is required to waive, modify, or convert fines if someone is indigent. And in those cases, then the person would be placed on probation just to have the probation company act as a bill collector. So I think the answer to your question is yes.
Thank you.
Senator Williams.
Along those specific lines, if we stop putting people who can't pay their tickets on probation, how far would that number drop?
You know, that's a wonderful question. I wish I knew the answer to that. The numbers are very hard to come by. As you might imagine, the provisions in this bill address municipal courts and county courts all throughout the state. If you can just think of the number of municipalities out there conducting traffic courts and the like. I don't know that there are numbers out there to be had without going to each court and figuring it out court by court. So I don't think we have numbers, nor do I think we probably will.
Do you think it would be a large portion, a large drop, a small drop?
I'm sorry, would you?
If we didn't put those people who could not pay for their tickets on probation.
Absolutely. A huge number of people who, just speaking anecdotally and as someone who is regularly in these courts, just a huge proportion of people who are placed on probation in our city and traffic courts are on probation just because they can't pay their fine on or before the day of court.
And it's my understanding, and correct me if I'm wrong, that currently, if you're on probation because you cannot pay a ticket, you have to pay the probationers a $35 fee every month that you cannot pay. This bill limits that to just 3 months.
That's correct.
Okay, so this bill would in fact help get those people off probation quicker.
That's correct.
Okay, thank you.
Any other questions? Senator C.
One last one, having follow up on the question. Is it my understanding that community service is still on the table
Yes.
for those that cannot pay, and they are proven that they cannot pay?
Yes, ma'am, that's absolutely correct. In fact, one of the changes that the bill makes is that it gives courts the authority to convert both fines and supervision fees, and that's key because those fees really add up, and it gives the court specific, explicit authority to convert probation supervision fees, electronic monitoring fees, all of those other kinds of fees into community service.
And last one. And in your opinion, that's a great thing, right?
I think that is a good thing to give courts discretion to do that, and I think it's a very good thing to remind courts and to have some kind of structure in the law, as this bill would do, that courts have to be very careful about how they interact with people who are coming before them who have no money and no resources to pay fine. And we really need to do a better job in this state of ensuring that we're not sending indigent people to jail just because they don't have money.
Thank you.
Yes, ma'am. Thank you very much.
Thank you.
Representative Powell, you'll come